Okay, here we go. Good morning. This is John Richardson speaking with you from Toronto, Canada. It is Wednesday, September the 24th, 2025. And with me today to discuss a very important decision that has the potential to absolutely reorganize the structure of American society is U.S. tax lawyer Virginia Torre Jeker. How are you today, Virginia?
Hello, John. I am doing very well, and I hope you are too. I can't wait to get into this case with you.
Well, would you say that, this case has the potential to fundamentally reorganize some of the pillars of American society?
Uh, I don't know that I'd go that far, but it certainly is going to be challenging
It
the
matters,
IRS.
right?
What was that?
It matters.
Oh, it matters. It
All right.
matters.
So the case is, what are we talking about today?
Right. So the case is United States versus Sagoo. It was decided September 19th, 2025 by the court in Texas, a district court in Texas. And this was a lady, Miss Sagoo. She was a U.S. taxpayer. She obviously had a lot of international ties, and she was facing a $1 million willful FBAR penalty because she didn't report various foreign accounts on the notorious FBAR.
All right. So
And
let's break that down a little bit, right? So FR is an obligation for U.S. persons to report non-U.S. financial accounts to the Treasury Department. That's accurate. Agreed.
absolutely.
Okay. I mean, more is required, but basically it's that. All right. And this is becoming a bigger and bigger issue in what I would call an international world where we have people coming to the United States, and retaining non-U.S. bank accounts. It's an issue for Americans abroad, et cetera, right?
That's right.
Okay. Now, at the risk of oversimplification, the failure to report these things can generate really nasty penalties. Yes?
Yes,
Okay.
absolutely.
And, this has really picked up, I guess, since 2003, 2004, what have you. But the law makes a distinction between willful and non willful, right?
Yes. Now, I think we should remind listeners that we are talking right now about civil cases of FBAR violations as opposed to criminal.
Okay. And we are specifically not in this podcast talking about the criminal ones, right?
That's right.
Okay. So civil, and even within civil, though, am I right in saying that they break them down into non-willful and willful?
Yes, that's correct. There's different penalty structures depending on whether you're found to be in willful violation of the FBAR, a requirement to file, or non-willful.
And very briefly, what would the difference be?
Okay, so in the old days, we had always hoped the difference was going to spin on if someone was willful, that it was an intentional violation of a known legal duty. So, for example, if you didn't know about FBAR, which many people didn't and still don't, you couldn't be found willful if that was the definition. As the court cases have developed over the years, our world, we have seen the courts say, no, 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 it doesn't mean an intentional violation of a known legal duty at all. You can have a willful violation because you were in reckless disregard of your duties to file this thing, or you had something called willful blindness and you didn't file it. So those concepts are really setting a much lower bar for the IRS to win and say, oh, this guy had willful blindness. He knew a little bit of something and he should have investigated further because, for example, he was asked on his tax return, do you have any non-US financial accounts? If so, you may need to file this thing called an FBAR. And he saw that in the instructions, but he never pursued further and found out more. So he just kind of closed his eyes to the whole thing. That's the idea of willful blindness. And yeah, you can have a willful penalty violation on that lower standard.
So would you say that the the assessment of willfulness is, in a very real sense, what I would call the sword of Damocles hanging over people in an FBAR case.
Yes.
So, yeah. So, I mean, this is
Yes.
a real problem, right? A real problem. Now,
It's so fact specific. There's so many different things that the IRS latches on to say you were willful, and the court has to consider, gee, well, what about all these different factors? The IRS will put their own spin on those factors, as the taxpayer will put their own spin on the same factors. So it is definitely a sword of Damocles just hanging there, and you're hoping it doesn't fall.
now, what's interesting is the way you put that. You say, the IRS would put their own spin, the taxpayer would put their own spin. Well, given the fact that we have IRS putting their spin, taxpayers putting their spin, do you think it's reasonable that the IRS can make a determination, judge, jury, and executioner? I mean,
Well,
why should
that's
the
the problem.
IRS be able to determine which spin is correct, right?
Well, that's the problem, because which spin do you think they're going to more likely go for?
Well, I think the IRS is more likely to go with their view of what it is.
Absolutely.
All right.
And that is precisely what this Sagoo case was all about.
Okay.
She was
Tell me
she was
more.
being assessed the willful FBAR penalty because she didn't file her FBAR reporting. She had various accounts in various financial institutions in the world. For example, one in the UK and India, and I forget which other country, perhaps it was Kenya. Yes, it was Kenya. So evidently this woman, Miss Sagoo, had some broad international ties, maybe to family, business, inheritance. We don't really know. The case opinion did not spell that out. But in any event, the IRS assessed these FBAR penalties, saying she willfully didn't file. And she said, no, I'm not going to pay. And the IRS went to court to enforce this and have it reduced to judgment so that she would be forced to pay. And the whole point that Miss Sagoo raised was exactly what you're saying. Hey, it's not right. I'm entitled to a jury trial for this kind of penalty. Under the U.S. Constitution, Seventh Amendment, the IRS cannot act as prosecutor, jury, and judge by assessing these penalties without giving me my constitutional right to a jury trial. And she was basing her arguments essentially on a very recent United States Supreme Court case that involved penalties being asserted against an individual by the SEC, the Securities and Exchange Commission. So that case, Jarkizi, was decided by the U.S. Supreme Court in 2024, and the U.S. Supreme Court said, yeah, we mandate jury trials for certain agency-imposed civil penalties, and the Seventh Amendment guarantees that
Right. So,
to
what the Seventh Amendment, I'm just going to read in the Seventh Amendment here because I think it's interesting. Here's what it says: in suits at common law, okay, where the value in controversy shall exceed $20, okay, the right of the trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. Now, undoubtedly, that's far more complex than it sounds, but I think it's important to note that this is a constitutional provision, right? It's not some, aspirational anything.
correct. And the
And this is
Constitution is very sacred. So, yeah,
so. I mean, this is actually what this Sagoo and the other one is saying. Is they're saying, well, hold on a minute here. I mean, the Constitution essentially requires that somebody have the right to a jury trial, right? And the way we teed this up, well, the IRS says one thing, the taxpayer says the other. I mean, that strikes me as a self-evident justification for having a third-party decision maker on that, right?
yes. And not any third party decision maker, in my view. So, for example, you could have a third party decision maker being a judge in a court, That's not the same thing as having a jury trial.
And yeah, I agree. And the difference would be what?
The difference would be, to my mind, you are getting with a jury trial a decision of your peers who may understand more about, let's say, real world as opposed to just looking at a legal concept and applying a law without a full concept and a full understanding of the context in which this law is being applied. So I'll give you an example of what I mean. If you have a jury trial for someone who hasn't filed an FBAR and the IRS is arguing it was willfully not filed, and you have a jury comprised of, let's say, a mix of, immigrants, dual nationals, US born and raised Americans, and they're going to be making this decision and discussing it amongst themselves in the jury room. Do we have the elements of willfulness? Yes or no? Why or why not? And all of that mix of people will be bringing in that are critical, especially in this area of willful FBAR violations, because I'm sure there are plenty of immigrants, plenty of dual nationals, plenty of people that, got a green card and didn't close out their foreign bank account in whatever country they came from. They will understand this concept and this dilemma that people are faced and say, well, was he really willful? I mean, gee, that's a very different perspective than, for example, a judge who has, lived all of his or her life in America and gone to law school in the States and so forth and so on. They may not really have the full flavor for what can happen when you are a new arrival to America, or can understandably, John, you've seen it in your practice. People don't understand what they need to do with regard to FBAR.
That's right. Yeah, there's absolutely no question about it. Well, listening to you describe that, another thing that strikes me about it is that, with a jury trial, right, you got a bunch of people who, are going to discuss this, right?
Yes.
And so they're sort of back and forth and trying to understand what's going on. I would think that's certainly, well, I don't think that is the case with a judge, but certainly if it is, it's far less so, right? So you're necessarily going to get a vetting of, a number of different perspectives here, which is great. But, this is, I think this is a very significant case, both on what it decides, right? That, you have a right to a jury trial and the assessment of these FR penalties. But I think more importantly, that this is beginning, along with the 11th Amendment decision in Showdown, right, beginning the rollout of a broader discussion of the importance of constitutional rights applying to things like FBAR, civil forfeiture, this sort of stuff, right? Do you agree with that?
Yes. Yes, I believe so. I think in part, John, this is, the IRS has been criticized by the Taxpayer Advocate Service, by, online bloggers, and for its very harsh approach when it comes to these FBAR cases. And I think this backlash is now starting to really be noticed, and some, very concerning things are happening with it. The courts are still saying now, wait a minute, maybe we need to do something here. I mean, look at the Bittner case, which said, look, the FBAR non-willful penalty is per form $10,000 a year and not per account that should have been on that form.
Right. So Bidner, though,
So, we've been seeing this whole development with FBAR over time, bringing some strength back to the individual taxpayer, and I think some much needed rational thought process going on.
yeah, I mean, at its core, what these decisions mean is the government can't always do what it wants, and they can't interpret things in any way that they want, et cetera, et cetera. But you wrote today a magnificent article in Forbes, which I certainly would refer people to, that that raises some of the issues that we've discussed this morning. And no doubt this will appear in your blog as well, which I would highly recommend to people. And maybe in closing here, if you could refer people to your blog and that'd be wonderful.
Absolutely. Yes. Well, this article was just posted in Forbes on the Sagoo case, Sagoo. So if people wanted to read that article, they could just go to a search engine and put in Sagoo and maybe my name and Forbes, and it'll pop up. And several days, it'll show up in my US tax blog, which people should really use as an educational tool. That's what it's designed for. It's www.us-tax.org. ORG is the domain. And it's got lots of categories. We do have a separate category on FBAR, so
Hmm.
people can, educate themselves and see what's happening. And typically I write every week, so I try and keep up to date and keep all my readers up to date as well.
Excellent. Well, thank you very much for taking time out in your busy day. And I mean, in closing, would you agree that FBAR is part of what it means to be an American citizen?
Yeah, absolutely.
I mean,
And FBAR is also part of what it means if you're a green card holder.
that's right. That's right. So, those preparing for the American citizenship test, forget, the Great Lakes and this sort of stuff. Get over and read Virginia's blog in the FBAR category.
Yes, John, for years I have been pushing that people should not be allowed to naturalize and become citizens, or they should not be allowed to get a green card unless they understand certain basic tax concepts that we talk about all the time, that taxpayers get penalized for not understanding. And it would just do them such greater justice if there were questions that they were required to answer about understanding their tax obligations,
Yeah,
even
I
though
mean, some of them, it might dissuade some of them from naturalizing or getting the green card, though, I mean,
well, fair enough. At least they're making an
but they
informed
should
decision,
understand it. All
right?
right. Thank you
Okay,
very much.
John, always a pleasure.
Till next time. Bye bye.
Take care.